All right, it's 1:30 and we've got a lot on the schedule for today. So I'm going to go ahead and get started. Thank you for joining us. Today is Wednesday, March 24th, 2021, and you're joining us at 1:30 here today on another one of Homeline's COVID-19 tenant landlord webinars. Today, we're going to be joined by Minnesota Housing Deputy Commissioner Rachel Robinson, and she's going to be going through an overview of the new statewide COVID-19 emergency rental assistance program. We'll also be joined by Homeline's Managing Attorney and Tenant Hotline Director Mike Bra to very briefly go through an update on the current status of eviction suspensions. We'll do that really quick right away, and then we'll get to Rachel later on in the webinar. So just a reminder again, what Homeline is. We're a statewide nonprofit organization. We provide free legal advice, free confidential legal advice to renters throughout the state. And we've served over 260,000 renters since opening in the early 90s. We serve folks in 4 languages: English, Spanish, Somali, and Hmong. And that's how you can reach our tenant hotline. If you're a renter in Minnesota, you can contact us there, or on our website. We have an email and attorney form that you can fill out and get specific individualized legal advice about your situation. Before we get started here, just a reminder about that we have been doing these webinars since last April and on a regular basis, and recordings of all the previous seminars are on our website. There's a COVID-19 tab at the top right of our website where you can access those, and you can access registration for future ones. We have a couple webinars scheduled for the future, and I'm going to talk about them really briefly here, and I will put registration links in the chat. If you're interested in registering for these, you'll also get a follow-up email if you're attending today with the links to register for these. But we're taking a 3-week jump here. We're not doing it. Our next one in 2 weeks will be 3 weeks from today. So that's Wednesday, April 14th. Just will be simply an update on the status of eviction suspension and what's going on with the rental assistance program at that time. April 14th is actually the day that Minnesota's current suspension is set to expire, but that we'll have updates hopefully that day on what's going on at that point. And then more than a month out, on April 28th, we're excited about this one. Some of you joined us in October of last year when we had housing attorney Andrea Palumbo from our office, as well as Leah DeGrazia, who's a law student that's with Homeline's office right now through the SAKE's Public Interest Residency Program. And they covered at that point in late October data on eviction suspension and the cases that had been filed thus far through the exceptions to the suspension. So we're going to be doing a full year review of evictions that have been filed during the suspension. Tomorrow is the 1-year anniversary of when the first eviction suspension went into effect. So we'll have a full year of data of how many cases have been filed throughout the state and sort of what they were filed for, what the exceptions were. We can go into detail on that. So that's on the 28th of April. Those are our next 2 seminars. Also, just want to give a plug really quick. We mentioned this 2 weeks ago. A former attorney with Homeline, Paul Bernberg, is doing a webinar, CLE credit for attorneys, next Monday at noon. And it's about residential tenancies, security deposits in residential tenancies. You can, I'll put the link to the registration for that in the chat as well. It's through the Minnesota State Bar Association and the Volunteer Lawyers Network. So before I hand it over to Mike to do a brief overview of the eviction suspension situation, just want to remind folks that we did get, we have a lot of folks on today, and our guest speaker, Minnesota Housing Deputy Commissioner Rachel Robinson, is going to speak about the COVID-19 emergency rental assistance program shortly. We have a lot of questions that were submitted in advance for her, as well as some legal questions that were submitted. So we're going to have Mike talk about the suspension briefly here. Then we'll get to Rachel to talk about the rental assistance program. and we'll have her field some of the questions that have come in about the rental assistance program. And then if there's time at the end, we'll try to get to some of the other legal questions that were submitted as well. So with that, I'll hand it over to Mike.
Thanks, Eric. All right, let's talk about the two moratoriums that we care about briefly before we have Ms. Robinson come in and tell us about the money. Okay, so the state eviction moratorium that has been in place since last year is still in place, and it goes through April 14th, so almost a month away. This has to be renewed every 30 days, as we've discussed several times. The governor has to say, I'm going to renew this once again under the powers granted with the peacetime emergency statute. How will the state moratorium end? Well, the governor could end it by not renewing it. The legislature could end it by voting both chambers to end the peacetime emergency. And again, the Senate is controlled by Republicans. The governor is a Democrat. The House is controlled by Democrats. And every time this kind of vote has come up, the Senate, again controlled by Republicans, has voted to end the peacetime emergency, but the House has voted not to end the peacetime emergency. Why it's still going on. There could be some legislation that ends the moratorium, and I'll talk about that on the next slide. The other way that this could all end is if a court challenge is successful at some level in Minnesota here, that Governor Walz's executive order power isn't valid somehow. The court challenges to that so far have not succeeded. So the Minnesota eviction moratorium remains intact through April 14th at this point, at which point it could be renewed for yet another 30 days, as it has been 12 times already. Okay, Eric, go ahead and take us to the next slide. So yeah, there are some competing legislative proposals, one in the Senate, one in the House. Both would add a new exception to the list of reasons why a landlord can file evictions currently in Minnesota. So right now, a landlord cannot file an eviction for non-payment of rent, but they can file an eviction for the tenant seriously endangering others, significant property damage, if the landlord wants to move in, or their family member wants to move in, or they need to move in, I should say, or if the tenant breaks the no drugs, no guns, no prostitution, no stolen property rule, the landlord can file an eviction. Both the Senate and the House version adds something called material breach, which is basically the tenant has broken a key part of the agreement. And these two bills that are at varying stages in the legislative process have very different timelines on when things occur. I'm not sure exactly how this is all going to play out. I just know that there are two active bills at the state legislature that are being considered. The governor's weighed in on some of this as well. And we'll see if something gets negotiated out in the end as a way to end the eviction moratorium, at least create an off-ramp for it. Go ahead and go on to the next slide as well. Thanks, Eric. Okay, that's not the only eviction moratorium that we have, though. The CDC moratorium, which largely prevents non-payment of rent evictions throughout the United States. It's not limited to one state, it's throughout the entire country, is in a little less stable position than it was when we spoke last. Last time we talked about the first case on the list here, this Turkle versus CDC, a Texas case, where the judge, a federal district court judge, had ruled that the CDC moratorium was effectively not constitutional. There's a lot more to it than that, but that was really the argument that prevailed for that judge. Several other federal district courts throughout the country had heard similar cases to that and had ruled that the CDC order, the eviction moratorium, was not unconstitutional. So they're sort of competing jurisdictions and judges saying what they think the rule is as far as a constitutional analysis goes. Since that time, though, since early March, we've had two other decisions that have held the CDC order is not valid for different reasons, though. Both Tennessee and in Ohio, again, both federal district court cases, looked closely at the statute that authorized the CDC to activate their quarantine powers, more or less, and found that there wasn't enough in the original statute, which wasn't created for the COVID-19 pandemic. It was created a long time ago. But it's what was used when President Trump at the time in September said no more evictions throughout the country through the end of the calendar year. So that was September through December 31 of 2020. relying on this statute that authorizes the CDC to have really broad powers on quarantining and stopping interstate traffic with plants and animals and things like that. And I think I read over the cases this morning, the Tiger Lily and the Skyworks case this morning pretty carefully. And this is what I actually was looking at when the original order was enacted by the CDC, the executive order was issued, was I didn't know that original statute authorizing the CDC to do this really said that the CDC had this power. I always thought that was the strongest argument that somebody could make against the CDC order. And now a couple of lawyers have made that argument on behalf of landlord groups. Is this academic at this point? Well, the CDC moratorium expires in a week, right? March 31 is when it ends. President Biden has indicated that he wants to extend this through September. There was some rumblings earlier that the CDC has sent an official proposal to the OMB, Office of Management Budget, that's not public yet, but suggests a requested extension as well. So we believe the CDC is likely to try to extend this. I do think, by the way, the argument under the Tiger Lily and Skyworks case goes away if Congress passes a new law. Then you're left only with the constitutional argument. Does Congress have the power to regulate evictions like this? But the Tiger Lily and the Skyworks arguments really say, hey, the CDC's authorizing statute doesn't give them the power to do what they've done here. It's a very different argument put forth by these landlord groups. And I think it's a better argument. It has a lot more likelihood to stand appellate scrutiny, which all of these cases I think are destined to face if the moratorium is renewed. Go ahead and go on to the next slide. And here's our map again. This matters because if there's an appellate decision in a district, it's got more precedential value in that district than it does elsewhere. Now, so far, we have district court cases only. So that's the entry-level court case in the federal court system, the federal district court. They're heard by one judge, not a panel, and they make their decisions based on what they've heard. Again, these are all going to be appealed, I think. I know that a couple of them have already been filed for appeals, and some where the CDC had prevailed, there have been appeals filed as well. But we have the 5th district, which is where Texas is. That's where the adverse to the CDC order is on the constitutional argument. And then we have in the 6th district, now we have Tennessee and Ohio, both having cases where a judge has said that CDC authorizing statute doesn't give the CDC the power to do what they did. So I think in the 6th district, it's a lot better argument for a landlord arguing, hey, this isn't being upheld, although still it hasn't gotten to the appellate level. So they're of limited precedential value, these district court cases, and very minor value in the 8th district, because so far we don't have any adverse rulings against the CDC in that district. Keep in mind, none of this really matters as long as the state moratorium is placed. The state moratorium is stronger for tenant protections, and the CDC is, the CDC order explicitly defers to the state moratorium if it has more protection in place for tenants. So it's not really that vital for Minnesota unless the eviction moratorium in Minnesota, the one through the governor, goes away through the governor removing it, the legislature removing it, or a court removing it. So the CDC has sort of been kind of this, in Minnesota at least, an invisible backstop if the eviction moratorium goes away, but it might be less stable than it was even a couple of weeks ago, I think.
All right. Thank you, Mike. So a reminder that, again, we've had a lot of questions submitted in advance. Probably the question you have about the rental assistance program has already been asked in Minnesota Housing Deputy Commissioner Rachel Robinson is with us, and she's probably about to answer it, hopefully. So, we're welcome to have folks submit questions throughout. Please do it via the Q&A, the question and answer system over Zoom. But you might want to hold off because we did get a lot of questions in advance, and we'll try to get through all of those. And then, like I said, at the end, the tail end of our session, as we get closer to 3 o'clock, Mike will answer some of the legal questions that were submitted. So with that, I'll hand it over to Deputy Commissioner Rachel Robinson. Thank you.
Thanks, Eric. Thanks for having me. It's great to be here, especially as things get closer and closer to where we'll have a program wide open, the second one that Minnesota Housing has worked on. So Eric's going to run the slides for me, and I just have a few. There's a lot of information on them. They're similar to what was shared with the Senate last week, but really I want to focus in on the now, which is what we call the COVID-19 emergency rental assistance. We do have a brand that we will release at the end of this week or early next week that's a little bit more catchy than COVID-19 emergency rental assistance. But Eric, if you go to the next slide. So you may be familiar, if you're watching this, and I think there's quite a large group, with last year's 2020's COVID housing assistance program, which was a program that Minnesota Housing put together with general CARES Act funds. So with the CARES Act funds that were not specifically targeted to any purpose, but came through the state. And Minnesota Housing used $100 million to help renters and homeowners with back payments. We came up with our own criteria, program, front to back, and closed applications in December. And some of those have been processing into this year, into 2021. But at the end of December, and we didn't have the language for this bill until late December, and then it changed pretty dramatically in the last week before it was passed in Congress and then signed by the president in the last week of December. That stimulus bill from December outlined emergency rental assistance. So this is where the federal government directly said, this is a program for renters. Here's who it's for. Here's how you can use it. States and localities and tribes or grantees, go. So then we waited for the Treasury Department to determine how much funding would come to the state and local partners and tribes. And then we waited for Treasury to provide guidance. That is where the guidance comes, but they have been coordinating with HUD. And we're at a point now where we know what we are doing. We have a good idea what it looks like, and we're within weeks of going live or opening this program. So again, the emergency rental assistance program is just for renters. That's really clear in the bill. That comes straight from the federal level. So this is a renter program that is meant for people who are within 80% of area median income, which if you're in the metro, you may be familiar with. That's higher than any other affordable housing program, and even across the metro is generally higher than, say, like the statewide 80% or poverty lines, essentially. So it's a pretty high level assistance for low to moderate income households. The program is meant for people who've experienced hardships, and we have a pretty long list of what that looks like. Essentially, if COVID-19 has been hard on your family, you can probably check that box, and who are facing housing instability. If you're behind on rent, that's certainly you're facing housing instability. If you're behind on utilities, or if you have a lack of confidence and ability to pay going forward. So those are the broad categories of the WHO. And the state of Minnesota had $375 million is the state bucket. And then there was more money authorized in the March stimulus. We actually don't even know how much yet, because Treasury still has to issue the final amounts and calculations that will determine how much more emergency rental assistance over and above 375 million would come to the state of Minnesota. And then on the next slide, I just have a few more details. Again, big picture about the program. So from that 375 million, 290 million came to Minnesota Housing. 85 million-ish of it, these are rough numbers, but pretty close, went to a combination of 7 local governments. That's the 5 counties of Anoka, Dakota, Hennepin, Ramsey, and Washington, and the cities of St. Paul and Minneapolis. And this was based on a population calculation in the federal bill. And so there are 7 local governments. There are some things that the local governments are working on, like Hennepin County put out an early application, essentially, testing the waters, getting their team to work, and they took as many applications as they thought they could handle at that time, but have since closed that program. And that's all using the same funds. But in the big picture, I do want to make clear to this group, we are sharing our platform for the application with the 7 local governments. So there is only one place to go for this rental assistance, one website, one application portal. It's identical. It doesn't say, okay, you're going into the Minneapolis portal. It doesn't say you're going into the state portal. You fill out an application for rental assistance, and then behind the scenes, we figure out who pays the claim. So it's not visible to the applicant. And that was something we've been working really hard with the local governments on. If you're familiar with the COVID housing assistance program from 2020, we used a group of local administrators, 52 of them at the state level, to actually accept and process payments. And so an applicant would actually know which one of the processors was working on their case. In this case, that's invisible. We are using large scale outsourcing companies for the really specialist in what they do for the actual application processing. So the applicant really won't know that Minneapolis is going to pay their claim versus Dakota County or the state. They apply, they get help, and we are working really hard to collaborate and make sure that that is clean and streamlined. Tribal nations, we think 9 of the 11 tribal nations in Minnesota receive direct funds, and these are direct from the federal government, the same flavor of money, the emergency rental assistance, but the tribal nations are setting up programs that work best for their communities. And so anyone who has an interest in talking to, especially if they receive services through a tribal nation, can just reach out directly. That's not something we're coordinating really heavily between the state and tribal nations. We're just communicating and staying in touch. The funding availability, you almost don't need to know that because it's not super relevant to what happens with an application. So I think we can move to the next slide. So I know there's lots of questions. I mentioned some of these things, but again, the assistance goes to the renter. That's not necessarily who it'll be paid to, but that's who the eligible party is. I know I have a lot of questions in the pre-questions and in the chat. From the federal bill, through the Treasury guidance, through what we've developed, this is assistance to renters to keep them stably housed. There is absolutely no way for a homeowner to get assistance, but if you are a renter of a manufactured home or a manufactured home lot with an owned home, that is an eligible expense. Utilities that are renter paid are eligible expenses, and other housing costs. So that may include fees up to a reasonable amount that a household has been charged for being late or for starting into the eviction process. And so we do want to help people stay stably housed, and we see those as associated costs. We don't cover things like insurance, taxes, phone, internet. Those are outside of what we've determined are the program priorities, but there's quite a long list that is eligible within what we've designed. Again, that 80% area median income, if you read the bill, you'll see a prioritization for 50% area median income. We do address this. There's a 2-pager on the Minnesota Housing website. It's a little more in the kind of policy weeds, but the priority for 50% area median income and people who are unemployed, we will address by taking applications on an open pipeline basis. And if we are not hitting a threshold that we've determined for 50% AMI applicants, we would address that by maybe, prioritizing at that time. We don't expect that to be an issue. With the COVID housing assistance program, the vast majority of households were low income below that 50% level. So we expect to serve people at that level, but this is assistance available up to the 80% level. I know I have a lot of questions about this too, and so I will address those independently, but there's this whole question of landlords being able to apply. It certainly seems to say that in the bill, but Treasury has made it clear, and our program, has to be designed to meet the compliance standards there are so many ways for landlords to partner with their tenants to get in a successful application, but the renter has to be income qualified, and we have to demonstrate that through documentation. So the renter has to provide that information and sign the application. I know I'm going to hear about the barriers there, and we want to be your partner and listen on those. But lots of ways for the landlord to partner, including initiating applications, filling out the application with the tenant. But the renter is ultimately the eligible party and the recipient of the funds. Go to the next slide and keep moving, because I know I could use the whole time just talking and there's questions. So there's the eligible assistance amount. The way Minnesota is approaching it is we are just going to take applications on a rolling basis. We've put the power behind our processing to try to speed up between an application and payment processing. And so a household who comes in April that has already been 11 months behind would be eligible for those 11 months plus 3 months of forward assistance. And so as long as they aren't going past this coronavirus time period of March 2020, going back, and 3 months going forward, we can do up to 15 months of assistance to that household. And we will process them for the maximum that they're eligible for. If a household's 3 months behind, they could get 3 months plus 3 months forward, so 6 months total, and they would still have a clock to run through to keep coming back for 3 months of assistance at a time. But I will say that Minnesota expects the funds will not last through all households who need prospective rent help for 15 months. It's a lot of money, but we certainly can use it when we start to cover the claims of people who are looking forward at housing instability. I know it gets in the weeds, but we'll just keep moving. So Eric, I'll go to the next slide, please. So we will be opening very soon. We will have information. You'll start to see invitations for more webinars and a very quick turnaround. Getting more information out that's really aimed at the public. We're finally at a place where we know Treasury is done issuing new guidance that would really change the program. So we know what we want to do. We will be getting information out on how to apply. And I want to make it clear that because we closed the COVID housing assistance program December 7th, we're 4 months of no help in the community. So people may have gotten even further behind. So we want to make sure we process the applications for people who are already behind before we start processing applications for people who only need help going forward. So we will first open for people who are behind. And then the payments go to landlords. So there is a component here. We'll have more information next week, but how landlords can get registered so that you can get paid. And the landlord will be offered the payment. We actually do a little bit of checking to make sure that we all agree on what you believe is the back rent due and what the tenant thought was the back rent due. If you're listening now, and I'll do this again in future webinars, but if you are a landlord with a tenant with back rent, one of the best things you can do for that tenant is to give them an itemized month-by-month statement of their total rent, how much they paid, if any, and how you applied it, and what is still due for that month. We have that compliance obligation to Treasury to have that level of detail for every payment we make. And so if we collect that all up front, it's a lot faster for us to get to the back of the application eligibility and then move to payment. If the landlord cannot be reached or refuses to participate, the assistance can be paid directly to the tenant household. And Congress has made it very clear this is not taxable income and does not impact eligibility for the household for any other federally funded programs. And then there's some work happening at the state to look at other ways that households might be impacted by getting a direct payment and make sure that we address those before any funds flow to the households. And so we do have this online application portal, and we're making sure that it's going to work really well before we open. No bugs. We really want it to work. Other states have used the same software vendor, and applicants who come ready with the 3 or 4 documents they need to finish an application are getting it done in 10 to 11 minutes, filling in their household information, rent ledger they have to do, and a few other things. So not too bad as a pretty complicated program goes, but it's still, a big online application. And so we know not everyone has internet comfort with the internet use of a computer. And so we do have a lot of other ways to get help. Certainly if the majority of people use an online application, that just gets them to the finish point faster. But we have a call center set up that is staffed 8 to 8, Monday to Saturday. I think it's 8 to 8. And we have that call center prepared to make referrals to a network of field partners. That's my whole next slide, but a network of field partners who are there to assist households who have even greater barriers. If even collecting the documents that they need is just not something they're going to be able to do without more hands-on assistance, then we have this network of field partners to do that. So we're really working to wrap around as much help as we can. And there is a hard copy paper application option between mailing it out and getting it back and getting it entered. It does create a small amount of delay, but it's really important to us to have that service. And we'll make that paper application in a printed version available out in the community, so that even if people don't mail it back, if they want to use it as a template for getting ready to apply, that they could do that. And use that format, because that's a lot easier for some people. So again, I think I've said it, and sort of as an apology, but just to be clear, there's compliance, there's income documentation, there's documentation that the household does live where they say they live and has a rent obligation. We need to see bills in order to pay claims, and we do need to confirm the person is who they say they are. And the same for landlords. We need to confirm you are who you say you are, and get information in order to make payments, so we can verify that you are, in fact, the owner of that property. So this last slide is just more information on the field partners. The field partners aren't the first place for people to go unless the field partners reaching out to them. It's a place where we are able to handle the cases. We have, can't remember if it's 26 or 28, but partners who are just getting under contract with us. They coordinate through our call center, through our back-end processing team, and really are looking at every case together to make sure that people get through the system as quickly as possible, which is really the goal. We want people to get the assistance. And so everything we've built is based on that theme of get you through the application, get you documented, eligible, paid, so that people can stay stably housed. That is it for my slides. And it's a little bit intimidating, but the chat is blinking at me.
Well, Rachel, thank you very much for giving us that overview. I think you've answered, I think, a number of the questions that got submitted in advance, and things that have come in the chat. But what we'll do is, if you're all right with this, we'll kind of just quickly plow through some of these questions that were submitted in advance, and then get to some that are in the queue. So first question in advance, Sky, a landlord, asks, can you apply for the assistance funding on behalf of a tenant that has moved out and owes numerous months of past due rent?
Yeah, I understand why that question is out there. The answer is no. The Treasury and the federal bill make it clear that this is for a household who's in place. And a household who's no longer in place is not an eligible cost. It's not an eligible household. So we are not able to use this assistance if the household is no longer there. And yeah, so that is the answer on that one.
All right. Emily asks questions about timeline. Has it been figured out when or how residents can receive funding? Is there a deadline for applying?
Yeah, so once we open, we are taking applications from people who are behind on rent at first. So we will not process forward only or utility only applications to start. The point being, trying to stabilize the housing market and stabilize housing for people who are behind, prioritizing our time and energy there. But We don't know how many weeks that'll take, but I'm saying weeks before we're just gonna be looking at our projections. And when we're feeling good about clearing the backlog, we will open to all applicants, which may include people who only have a forward rent concern. There is no deadline. Depending on how we run the numbers, we do run out of money. So that's not going to be in 1 month, 2 months, 3 months, but it will happen. And so we have a continuous improvement mindset, a continuous program mindset. There's a chance that the federal government will recapture funds from places that aren't spending and make them available to places that are. And we plan to be one of those places that is using the resource and would be eligible to get more. So we'll communicate as we know what's happening, but there is no deadline, and we don't expect to be in a place where we're looking at the end of the program for many months ahead.
All right. We've gotten a lot of questions that have come in advance and during the session about eligibility of tenants that have some sort of subsidy, whether that's housing supports, project-based Section 8, a subsidy that allows them to pay 30% of their income, housing choice vouchers, Section 8 vouchers, et cetera. Those types of programs, can the tenants that get a subsidy like that apply?
Yes. So if the tenant paid portion of rent, so it could be up to 100% total assistance, is an eligible expense, we will pay those claims. So even if a household's net obligation after receipt of assistance is $100, if they have not paid it, that is an eligible claim, and we would, they have to apply, have to be eligible, but we would cover that cost. And we were waiting on that from Treasury. The outgoing Treasury administration in early January had said kind of no, kind of yes. And then the new Treasury staff said, no, yes, it is definitely possible to pay claims on all kinds of subsidized units. And so we allow all. There are other places. So if you're spending a lot of time on the policy, there are other states where they're requiring tenants to go back to their administrator, say their property manager, to ask for other concessions. We are not doing that. We think that's very burdensome and complicated. Every program is different. Every manager is different. And so that tenant side of the obligation is enough to come to us, ask for assistance. And we know from talking to our community and folks in the subsidized world, from HUD properties to housing supports, that tenants are behind on their tenant portion. And so it is a real challenge and a real risk out there.
All right, good to hear. You covered this a little bit, but the qualifications, are they different than regular emergency assistance under county programs?
It's almost, could read between the lines, but to be clear, it's 100% assistance. We do not reimburse. This is the rules, not just Rachel, but the rules. We don't reimburse for back rent, utilities, and fees that are already paid. So we can't pay somebody back, even if we know that they stretched to make that payment. I get it, but that is not an eligible cost. But going back and going forward, it can be up to 100% assistance. So there is no household contribution requirement like in a lot of other programs. And it is up to that 80% AMI. You'll see in our program guide when it's released, we'll have some tests of kind of the outside situations that we probably would not approve. We're not looking to subsidize penthouses, but we don't want to try to make a rule for penthouses. So we're working with what we've got, but the assistance does not require a tenant contribution.
All right. There's a question from Joyce, and this might be, I think, a question about if funds might be available for folks that have been able to move out of a place where they were sheltering, maybe a homeless shelter, or maybe they were staying with friends and they're maybe moving into a new housing opportunity, but they might not be able to get up on their feet right away with full rent payments.
Yeah, I would almost, call this a new housing situation or rehousing. Yes, technically, a household can apply for this assistance for a new rental situation when we open for 3 months forward rent at a time. The circumstances where that will work, I think, will vary, and certainly it could happen, but Security deposits, we will consider an eligible housing expense as, and the household needs to come to the application with a rental agreement. So the circumstance would require that the landlord is working with the tenant to have a future rent obligation, knowing that the tenant is pursuing assistance that is 3 months at a time and subject to a review and determination. So this is actually something on our list for, how would we enhance this as the program during the life of this program, enhance the opportunity for new housing situations. So it is a yes, definitely would process this. It's probably one best to be working with, call 211, get us a little extra help to make sure the paperwork looks right, but it's possible. It's a yes, but it's not an easy yes because of the requirements.
Okay. This might be a tough one. Carmela asks, I'm wondering how this program might assist people who currently have unlawful detainers or eviction records and are not able to pay them. So, yeah.
So yeah, as long as the housing cost is no earlier than March 13th, 2020, if it is an eviction related cost, a fee that we find reasonable, charged to the tenant related to their housing stability, that is an eligible cost. So we don't think we're doing tenants any service by paying some, but not all of the expenses that would get in the way of their housing stability long term. So if I'm reading the question right, and I had to ask somebody, it's somewhere between $300 and $400 is this cost, that would be an eligible cost.
And you touched on this a little already, but Brittany asks, will landlords have more direct access to funding due to tenants that might have high barriers and not be able to access it themselves?
Yeah, so understanding that the level of barriers that a tenant might face might be so high, including communication barriers between the landlord and the tenant, that you may need to wrap around some help. So I really encourage people to use the call center, other resources that will be available as part of the program on our website, and try to address the barriers, because at the end of the day, even if the landlord, which is allowed, sits with the tenant and outside or safely somehow, but and enters information for them next to them into a computer with their help, the tenant is the applicant and has to be participating. So, yes, a landlord can really work hard and do use the resources that we have available, but there would come a point where if you just can't get the tenant to agree to participate, that would be ultimately a barrier.
And I guess this is a question following my own question following up on that. The list of community partners will be something that people will maybe know, or they'll be able to coordinate with their tenant and with some of those folks if they know that a tenant maybe needs assistance.
Well, the list would be available. We really don't encourage people to go straight to a community partner. We're triaging through the call center because we've put a lot of resources into the field partners, but it's not enough to do one-on-one help for every situation. And so we want to figure out how much can be worked through with the call center, and then what's the right field partner for that. We have culturally specific field partners. We have geographic coverage field partners, some who specialize in other, maybe more with the court system or with certain language and accommodation services. So we want to make sure that we match right through the call center to do that.
All right. Valerie asked, how much money will there be? Will it be like the CARES Act funding?
Yeah, the beginning of the presentation, I laid out the numbers, but I can reemphasize those. So the 2020 COVID housing assistance program was 100 million. The state overall has 375 million from the December stimulus, of which 290 is Minnesota's. And the American Rescue Plan Act that passed in March includes more emergency rental assistance that refills the bucket, even though we have to do separate compliance on it. And it's the same program, so it flows through the same application, the same portal. And we don't have numbers yet, but it's a big number, in the 100 million plus. So we won't know until Treasury does the formulas are different, so we actually have no way to guess right now.
All right. Peter asks, is there help available for HOAs?
I think for a homeowner association, no, a homeowner would not be able to ask for those expenses, and the Treasury has made that clear. If a tenant is renting the premises and the homeowner association fee is part of their rent agreement, and they cover that, again, the tenant would need to have an obligation to pay that is either past due or forward, then yes, but generally no, the answer would be no for homeowners.
Okay. A question from I think a service provider. If clients receive unemployment but didn't use it for rent, will they still be able to get assistance?
We do not test the household's ability to pay the rent, only their income, their housing instability, their COVID impact. So being unemployed is COVID impacted. So we do not look at whether they coulda, woulda, shoulda paid. We look at what is due, what the situation is, and what the income is for the household.
Okay. A question about the application process. How might applicants check status on applications if they don't know who is processing their application?
Yeah, the software system, one of the things we liked about it when we picked it is that it does have status updates. And then there are metrics in the background on how long, how much time has passed between all the different statuses. There's like 15 between submitted, processing, pending, pending this, pending that. And so when a tenant is using the internet, or someone who's assisting them, family, landlord, friend, community partner, they can log back into their account and see their status and get more information on that status. I've been playing with it a lot, and for anyone with any internet comfort, it's pretty user-friendly. It won't say pending Minneapolis or pending state, it'll just say pending, because all of us are using the same system. It's also a processing system. So actually the application stays in the software and we process it in the software. So whether you work for Minneapolis or you work for the state, you are processing it in the same place essentially. And so that's great, but we also know people don't have internet. So 211 has the ability to look at status with authorization from the tenant and the field partners. If they are assisting a household, have a view in to communicate and look at the system for all of their clients. The tenant doesn't have to authorize this. We have to be, thoughtful about privacy, but there is a way for folks to look. And then if the landlords have registered, not as good training on this side of the application, but if landlords are registered and connected to a property, and they can actually see the applicants who are residents of their property once verified, and the statuses on those tenants. So there's multiple ways to look, and status is really important. We heard a lot about that from the COVID housing assistance program last year.
All right, thank you. Since you're talking about the application and that processing system, question about what languages that's going to be available on online, the online application as well as the paper application, what languages?
Yeah, we are starting with the online application available in English, Spanish, Somali, and Hmong. We have a couple other language requests, but they're going to take a little more time to translate for Oromo and Karen.
Great to hear. A question from Kimberly. Are you able to tell us at this time if a tenant applies to the program, will someone from the program then reach out to the landlord, or will they only be communicating with the tenants?
We do reach out to the landlord. So when the tenant is applying online or with help, you get to the Who is Your Landlord section. Anything you know about them, you would share. So if all you know is that, and I do play with the system a lot to see how this works, and I pretend to be lots of different people on both sides. So if all you know is that your landlord is named Bob and their phone number, but you've also put in your home address, you have a piece of paper that shows that's your home address, and Bob and phone number, we have a bunch of duplication checks in the database that when Bob or Bob's property manager with a completely different name is setting up an account for that address that they own, and with information that matches what the tenant put in, we are able to match the tenant and the landlord. We will reach out to landlords. We are required to do so under the federal program to make payment. If we are unsuccessful reaching a landlord, then we can make the payment to the tenant directly.
Right. I think you maybe answered this already. Landlords and tenants can work together on the online application.
They can. The application can be filled out by someone who is support or proxy for the tenant. That is absolutely possible. You'd have to have their information, so they need to be there. But
yep. Will you allow payments to go to a property manager and not have to go to the address on the W-9?
We are going to do some more landlord training. I'm not sure I can answer that question right now. We're actually going to ask the landlord community to engage with us a bit more on organizing how you want to get registered in the system. And I have more to come on that.
How often can a household access this assistance? Can they use it more than once? If they access it more than once, do those who have gotten assistance from the program get priority?
So a few different ways to answer that. It's a great question. So the households are limited to a certain number of months of assistance, and that's going back and going forward. That means that if you are only $50 behind for April and you apply for that $50 of April 2020, you have used a month. And we've pushed Treasury on this, and that's the breaks. So if you use 11 months of back rent, then the household would still be eligible for 4 months of forward rent. But then I get to add another caveat, because this is fun federal program stuff. The American Rescue Plan, we can use those funds combined with the December stimulus for a total of 18 months. So 18 months, let's use 18. So a household would be eligible for up to 18 months of total assistance. Once you've applied and been determined eligible, and this is all federal guidance stuff, but if you used a tax form to complete your income qualification, the reapplication for another 3 months of help is basically a no documentation. If you're still living in the same home, same rent rate, and you used a tax form for your income, it's just a re-upping. So absolutely that would advantage a household not really doing anything except going in and saying request assistance and go. If a household has much more dynamic income or does not have tax forms or the ability to get them, then they would have to bring new income documents to the application with them. So it's a little bit of work, but households who are in the system have been determined eligible. We've done the work to check their address, absolutely have a faster track to staying in and doing 3 months at a time up until we run out of money or it's 18 months total for the household. Did that even make sense, Eric? Did I?
Yeah.
I get there.
I think
it's complicated.
Yeah. And I think one hurdle you mentioned is that because they're different programs, there's slightly different requirements on the federal level, right? So
there are.
That complicates things. Okay, here's a lightning round of questions I think that you covered, but we'll just confirm. Can the funds go towards security or damage deposits?
Yes, but in the circumstance where a household has a rental agreement moving in, or if it's related to housing costs, kind of going back to that March 13th, 2020.
And then the income max on the program, 80% AMI, right?
That's correct, and that is adjusted by the area median.
Yeah, so area
and,
AMI,
and household size.
80% AMI, area median income is based on the location where the tenancy is.
And in the online application, early on, you enter your zip code and it pulls up those limits. And if households get stuck there, there's an info box to just call our call center and get assistance understanding. We also try to help inform people that if they are receiving certain kinds of other assistance, those are all within 80% AMI. Unless your income's gone up, assume you're eligible, keep moving for the programs that we know are always within 80 across the entire state.
And eligible expense, a down payment on a manufactured home, probably not. No.
That'd be no. Yeah.
Let's see here. If a tenant received assistance in 2020, an example, 5 months of maybe the previous program, does that 5 months count towards this upcoming maximum?
We don't believe that it does. I think early on there was some question of whether you had to attach that to the timeline. We don't believe that is the timeline. So you can't ask for the same assistance for the same months. The law is clear about that. But if you received it, but it doesn't start your clock, so to speak, the 18-month clock, as we understand it.
All right. And then somebody asked a clarifying, maybe missed earlier, rental assistance is paid to landlords directly, except in certain circumstances, right?
That's correct, yeah.
So here's a question, or maybe a statement. Landlord that has several tenants that are purposely not working or working for cash. We also have tenants who say they have the money but are withholding so they can apply for assistance and use their money for something else. Why is there no checks and balances with this program to avoid misuse to go to people really in need? Also unfair for landlords to have to wait months while tenants purposely hold waiting this possible assistance.
Yeah, there's nothing built into the way we do this that would ever tell us what other means someone had or had the opportunity to have. And there's just no way we could build a program that would do that, even if that were of interest to us to do so. So, yeah.
All right. Last time renters waited sometimes 2 or more hours to speak to someone on the 211 line, which was kind of the primary way that for the previous program. Is there any idea about the expected phone wait time, considering that the phone might be the first stop for many renters looking to apply?
We know that can happen. We can't make promises that it won't. We certainly want people to access the resources that we're putting out into the community. And we know that our first day, our first week is going to be really intense. So we are prepared for high call volume, but I understand that has happened in so many programs, including the COVID housing assistance program and other rollouts, that boy, are we aware, and we're doing what we can, but we can only have so many trained call center employees. It's a big staff between the people who process applications, the field partners, and the call center. But now it could happen. I appreciate that people worry about that.
This is an unprecedented program, just like the last one, right? Minnesota's never seen something like this before.
Oh, absolutely not. Yeah.
If a tenant is undocumented, will they be eligible for this assistance?
We do not ask any questions that would indicate or require paperwork regarding household documentation. So this is pretty much a closed system, but we do have the warnings that one would expect on our front and center on our front page about how data will be collected and used, but we do not require a social security number to move through. We do not require any other documentation. We have lots of ways to demonstrate income.
Somebody, one of our attendees is asking, can they be trained to help their neighbors, their friends, and other folks apply?
Yeah, good question. We are working on what will be released next week is Get Ready materials, and those are meant to be volunteer, family, a concerned person, all the way through tenants themselves, seeing this material and having it help them understand what they need to do to apply. But it's a good question about training, and something I can put on. Alyssa, I know, is listening as well. We can put on our list. Just beyond those who we are compensating to work with us on all this work, we're so grateful to hear when people want to engage and get the toolkit from us on how to help people get access.
If a tenant doesn't have documentation of being behind, what will qualify them to receive forward payments for rent?
Yeah, so if they are not behind or can't demonstrate that they're behind, once we open for assistance after we've cleared the backlog of back rent, we will open for forward rent. And it's just the baseline qualification. So within the income limits, COVID impacted, facing housing instability, and I don't think there is a fourth, renting. So those are the requirements. So, households share with us the circumstances that have put them in the COVID hardship and housing instability category. And that's what they need to do.
All right, thank you. A comment from Adam here. The 2020, the new rental assistance programs that I guess maybe are similar to this one are already up and running in Milwaukee, Wisconsin, and other parts of the country. Is there a reason why it's taking longer here in Minnesota?
There are some programs that are open. We have a great peer network of states as well as localities. There are hundreds overall. The Treasury gave us both rules and flexibility. So every program is different. Some opened, then closed, then we'll start processing applications. Some opened and had to close because their software didn't work. And some who are using the same software provider as us are open, and we're learning from them what's working and not. We have a very unrestricted program compared to many of our peers of our size. So that is taking us a little extra time to make sure that our website can accommodate lots of different avenues to provide information. So we take more than a tax form, more than a tax type form, more than pay stubs, so the longer that list is, the more functions we have to build in. And it's just been my goal when that website is live that it works. And it's not going live until it works. So, it works, but we want it to really work.
Yep.
And answer all those questions and be intuitive.
Well, yeah, and there was a question or a comment earlier about there's been other state websites that have had troubles with a lot of traffic. And so that's obviously a concern and something that you are hoping that will be dealt with on this program.
Yeah, absolutely.
Does this funding also cover late fees, garage fees, pet fees, or strictly rent only?
It does cover fees. I cannot remember how far we've gotten in addressing the reasonableness, but it does cover fees.
If you're currently living in temporary housing, does that qualify, like an extended stay type situation?
Yes, great question. I didn't get to that in the talking points. Yes, if you are accessing in a hotel informal lease, it might take a little bit of extra work. Maybe call the call center to get the right kinds of documentation and make sure that our case managers are ready to look at the application for what it is. Absolutely, that is a housing cost behind, and then when we open for forward, as long as we can demonstrate that housing cost, demonstrate that's where you live, absolutely we will cover those costs of hotel, extended stay, informal leases, and non-traditional properties.
There's been a couple of questions, and you've covered this a little bit, just in terms of what the documents that might be required, both documents that a tenant is required to use to demonstrate their household income, but also a question about do they have to provide a lease agreement, or does the landlord need to provide a written lease agreement?
Yeah, I should almost pull up what we have written that'll be available next week. But there are categories of documents. So every adult in the household needs to provide documents on income. Because of that repeated testing, if you have filed taxes for 2020, if you do file taxes, we know that's a lot of people will not fall in this category. But if you do, and you're a tenant, the 1040, assigned 1040 for 2020 is the fastest document to bring to the table. But if one household member has a 1040 and another adult in the house does not, you can have different documents per adult. But every adult has to bring those documents. So if you have other stuff, W-2s, receipts, 1099s, just get them ready. If you are working with current income and don't have annual income statements, gather what you can. And so that may be pay stubs, it may be receipts, it may be, a screenshot from your phone, so showing what you brought in from working on an app-based service. It could be a statement from an eligibility program that you are enrolled in that provides general assistance to your household. Bring what you have for that current income determination. We're just looking to find you in the limits, but we do need to test income. We do need to figure out that you are within the income limits. If you truly have no income, and in a household where, say, it's a 19-year-old with no job, it's It's going to be pretty easy for our case managers to figure that out if one household member has no income. But an entire household with no income, absolutely a circumstance we do see, is able to self-certify no income. But they do need to meet the standard for no income. So income documents. And then there's the bucket of lease documents. So the federal government did give guidelines, sort of cascades through options. A lease is the best. It's signed, it shows the rent amount, it shows the address. That's the best document if you have one. If you don't, something landlords can be doing now, and that we'll share with landlords in the next week, is a rental letter or agreement. So if you don't have it, don't do leases, haven't done one in 25 years, a piece of paper that lays out the terms and conditions signed by the landlord will be hugely helpful and can serve as a substitute. And we can accept households demonstrating in other ways that that's where they live and that's what they pay. Variety of options there. I'm not sure I can detail right now, but start working with, with what you have, or a case manager or volunteer on, well, I can show that I paid it. I just can't show that it's actually a lease, and just start collecting that information, because we can process a claim on that. And then for back rent and back utilities, we need a bill. We need an invoice, and it needs to show the month when, and I think I mentioned this before, again, this is Treasury. Treasury makes us report at this level of detail. So we have to pay claims at this level of detail of the month, the total amount that was due, what was paid or applied, and what is still outstanding. For forward rent, it's really based on that rent agreement, but for back rent, we've got to have bills. Back utilities, which is gonna be on the tenant side generally, we've got to have bills. So those are the big buckets. If you're having trouble demonstrating something in one of the other buckets, a utility bill charged to you at that address is going to help bolster your application. Otherwise, we'll have to call you and ask for it. If you do submit an incomplete application, it takes longer to process because we have to wait for it to get in the queue, the processor to look at it, and then they'll look at it and say, well, it's incomplete. And then they will follow up and try to get the application completed. But the back and forth, can create a lot of phone calls, texts, emails, time, energy. So the best thing that anyone can do is sit down, finish the application front to back, and put in the documents that fill those categories. But those are the categories: is income, rent agreement, and bills.
And related to that, do you have to prove in those documents somehow that your income has decreased?
You do not. There is a place in the application where you share, we don't want anything super private, but where you share how COVID has impacted you, and we give lots of options to examples of what that might be.
Okay. A couple of logistical questions here. Could we receive a copy of your slides? Are you okay if we post those with the recording?
Yes, we have. These are in the public realm already, so I can say that.
And I did put a link, and I'll put it again at the end of the seminar here, to Minnesota Housing's website and the specific page that has a little more detailed document on this. But we'll post the slides. Again, we are recording this, and the recording will be up on our website. So if you missed something earlier, you can circle back and watch it on our website. What if the tenant disputes the amount the landlord says is owed, and will the program be confirming that that late fees can only be charged at 8% of the overdue rent amount, which is a state statute?
We will look at the reasonableness of fees. I'm not sure I heard the first part of the question, but we will look at the reasonableness of fees, and I can't detail that right at the moment.
The first part was just if the total amount, if the tenant disputes it, disputes what the landlord is saying, what happens there? Oh,
there is some process. If there's the tenant makes the request, or the tenant with the landlord's help, somebody makes a request for assistance on the tenant side. On the landlord side, it's called an invoice in the software system, but the landlord, if the landlord and the tenant don't agree, our team will follow up to try to figure it out. We expect a lot of that to happen. So the example of, households started getting behind in June, but has been bringing money to the office. Well, maybe the household thinks they brought when they brought 200 in July, it was applied to July. The landlord applied it to June. We expect that to be pretty typical. And so I do think if you have a statement as a landlord of what you are owed, then providing that to the tenant and doing it in a scanned format, if they have email or the ability to use a computer, will save time, because then you're kind of starting out on the same page about what is owed.
Is there any avenue or place to report fraudulent claims or applications?
That's a good question. We do have one for Minnesota Housing, but I will need to connect on what we will do for this site, what that contact information will be. That's just, it will be obvious, but that's a good question for me to make sure is on our list.
Some questions about when it's going to open up, when paper copies will be available, what's the website that people will be going to. That's all going to be announced fairly soon. Is that right?
Announced soon, yeah. We don't want to send people to teams that aren't ready to handle their phone calls, or websites that aren't ready. But we are really getting very close. We know the program isn't going to change much from this point. We are at the design is done. So we're really into the details at this point.
All right. I think you answered this already, but somebody who became homeless, they would still qualify if they're looking for a place?
They would. Again, a rental agreement, when we open for future rent, would be part of the package. And so, figuring that out with a case team is probably pretty critical to get that application incomplete so it can be processed quickly.
And then do you have, I think you've spoken to this again, but once the application is complete, everything is in, is there a estimate of how long it will take once the approval has happened to when the payment will go to the landlord?
We don't have an estimate of that time. We've put together a really strong processing package, and the way that we pay out from the bank, and we're working to speed all of that up. But it's not overnight. This is not Venmo. There's time in between an application and the payment. There are waiting periods between to verify a landlord who's new in our system. So those things can really add up to be somewhat longer, but we are constantly working toward really shortening that eligibility review. And a complete application where it's really clear you are who you say you are, you rent where you say you do, your income is demonstrated with some clean documents. Those are going to be easy to process, and really will shorten that time frame. But we're ready for all of them.
All right. Question about that there's this program is specifically focused on tenants, and there's a lot of programs out there for renters. Is there, what's available to help homeowners? Is there any programs out there that you're aware of?
Yeah, we were surprised a bit in December that the stimulus bill did not include homeowner provisions. We had covered homeowner payments as part of the COVID housing assistance program in some circumstances. We worked together last year with the governor, the attorney general, and the Federal Reserve to work with more banks to soften the out-ramp, the outrun way, whatever you call it. My words are failing me. But for people who were and like leaving a forbearance period when that time would come up. But there was nothing in the December bill. The March bill has a $10 billion national program for homeownership assistance fund. We're still waiting on Treasury guidance. They're acronyming it already. They call it HAF. So they have a name for it. But the bill information is available on a number of the really good sites, probably some that Homeline connects to. And Minnesota Housing will be the recipient of those funds when we figure out how much comes to the state. But it's not a huge program. It's not as big as the emergency rental assistance. So we're staying tuned as we look at infrastructure packages and other policy proposals, because we do hope to see more for homeowners.
Right. Well, Rachel, we had asked you to set aside until 2:45. Do you need to head out now? Can you answer a couple more? We also wanted
It's
to
up
leave
to
a
you
little.
if you wanted to use any of the time, but I'm here if
All
you
right.
want.
We'll throw a couple more questions your way, and then we'll shift gears and answer some of the legal questions that came in. And again, so greatly appreciate your availability to talk about this program today and answer these questions. And it sounds like the Minnesota Housing is going to be having some webinars in the near future to do just this, to share more about it and the process, and answer questions too. So this is not your last chance to ask questions. I lost the question I was going to ask. Oh, I think you touched on this, but there's a requirement to say that the household has been impacted by COVID. Is there some guidance on exactly what that is? I think you mentioned there's maybe a check boxes on the application or something.
Yeah, they are. I don't expect these to change, so I can do a quick. Essentially, if your household income has dropped, if you are having trouble with other increased costs, including childcare, the strain of having children at home, the cost of transportation, forced leaves from work, other family members joining the household. It's a pretty long list, including other. We don't want to hear about your medical situation, but certainly things that like, please don't share private information, but share that the COVID-19 pandemic has hit you hard, and essentially low-income people who can't pay their rent have been hit pretty hard by COVID-19, disproportionately for Black, Indigenous, and people of color, of course.
Let's see here. There's no sort of work requirement tied to this program, or requirement that someone's looking for work, right?
No, and Congress certainly didn't intend that when they passed this bill. They really wanted to infuse help into an extremely strained population of renters and housing market. And so they didn't want to tie this to all the other things that people might need or do. It is really meant to get the money out to stabilize households and stabilize rental properties.
Here's a technical question from Linnea. Would ground lease fees for homes in a community land trust be an eligible expense? Seems similar to a lot rent for manufactured home.
It's more of a legal question, but there is a deed involved, so I'm not so sure. I'll have to check on that.
All right.
Put that in our FAQ.
If an example, if 3 months of past rent is paid, is it automatic that they'll get 3 months going forward?
When applicants come in with past rent applications on day one, we encourage them to check the box. If they reasonably expect they'll still be in that rental situation for 3 additional months, check the box for forward, and we will process all of the eligible months back and forward. That helps keep people stably housed. Well, we don't want to keep processing them 3 more times in the next few months. We want to limit our number of administrative touches with that household too. So benefits us all if people come in. We try to make it obvious, but certainly we hope people know that everything back and forward for 3 months, and we will process to that extent.
All right. Another question here. If a tenant has recently gone through a name change and the new name's not on documents, is that going to be honored?
Certainly, we'd be able to review the application. It's the kind of thing that would create an exception. The more information someone gives us about that situation, the easier it is to do without following up. But it's kind of a regular thing that happens, and we're prepared to handle. It wouldn't prevent someone from getting help. All
right. So let's do this one last one, and then we'll shift gears to answer some legal. This one is actually, I think, maybe a combination of a question about rental assistance and legal question. It sounds like a landlord's asking that several of my leases have expired since evictions aren't enforceable, and holdovers may become an easier path to deal with tenants who've simply been gaming the system, as others have mentioned. Tenants are paying for other things rather than rent. So if tenants are still living in the residence without a valid lease and intend to stay, can they still get rent paid 3 months ahead?
If they have a reasonable expectation that they will be there, then we'll offer payment to the landlord. If the landlord takes it, you're taking it for those months of rent. So certainly our expectation is the tenant stays in place. Otherwise, you would need to return the funds.
And
But we leases are complicated. We don't want our processors spending a ton of time with them. So, you know, a lease is a lease. It's good if you know your lease has been expired for a long time to put something else from the landlord on top of it that says that it's still a valid rental agreement in place, or the renter is in place. It would help.
right. Well, yeah, and the legal part of that is just that, I guess, during the suspension, leases, part of the suspension is that leases cannot be non-renewed or terminated by the landlord. So the lease didn't expire. It continued. It likely continued to renew there. So, all right. Well, again, thank you so much, Deputy Commissioner Rachel Robinson from Minnesota Housing. We appreciate you sharing details about the program, answering a marathon session of questions. And we look forward to hearing more about the program once the application opens up in the near future.
Thank you. I know everyone's eager. It's driving us. We really want to help. And we're looking forward to the next few weeks and the go live. Thank you so much, Eric.
Thank you. All right, so we're going to bring in Homeline's managing attorney and hotline director, Mike Vra, to field some of the legal questions that came in advance. I think there's one or two that came in during the session today too. We see all of your questions that you submitted that we didn't get to that were directed to Minnesota Housing. I think the best thing to do right now is we will, like we said, we will post the slides from today, and then we are recording today's session. So on our website, there will be a recording of the entire session. So some of those answers might get, some of those questions might get answered if you review the recording. Otherwise, Minnesota Housing is going to be putting out more information about the program, and they're going to be doing their own webinars. The place to go to get information about the new program is in the chat right now. And with that, I'm going to start lobbing questions at Mike. We got about 6 questions about what is the status of the eviction moratorium? When is it ending? Will it be lifted? What's the and then what's the off-ramp plan?
Right. We talked about this at the beginning of the session. These questions were actually submitted in advance. Again, the state moratorium goes through April 14th, the current version, but it could be renewed for 30 more days, as it has been every 30 days since last year. The CDC moratorium ends March 31. That's the federal moratorium. Rumblings are that it's going to be renewed again. There are court challenges that are becoming a little more substantial at this point against the CDC order. The off-ramp at the state level is in process right now, is the best way to put it. Both the Senate and the House have their own versions of what that might look like. And so we can't really get a definitive answer on what the eviction off-ramp will look like. And we're going to stick around to answer the questions that we got that are legal questions. Rachel was very considerate and stuck around for a little bit extra. But now we have shifted, as Erica said, to just the traditional stuff that we typically cover, the landlord-tenant legal questions. So happy to answer those as long as they keep coming in.
Yeah, so Lindy says, my landlord sent me an email saying I'm evicted because of several 911 calls in a weekend, which did not directly link me.
Yeah, so right now, a landlord, first of all, you can't evict somebody through email. That's not how it works. If a landlord really wants to evict a tenant, they've got to file a court case called an eviction or an unlawful detainer and win the case. Right now, it's very difficult for a landlord to file an eviction in Minnesota. It has to be an exception that you, the tenant, has seriously endangered others on the property or significant property damage. The landlord or a family member needs to move into your unit, or you violate the no drugs, no guns statute that predates the eviction moratorium by 20, 30 years almost. Without that, the landlord can't make you go right now. If the landlord tries to make you leave, you should contact the Attorney General's office, or you can certainly contact our office at our tenant hotline, and we can talk about the actual facts of your case and see if there's one of those exceptions that might fit, that the landlord might be able to use to try to evict you through the court process if you don't willingly go.
We got a question about today being CLE credit. We're not applying for today for CLE credit since today's session was primarily about the rental assistance program. But the future seminars on the 14th and the 28th of April are, we will be applying for CLE credit. And again, I'll post the links to those. Here's the information about our upcoming sessions. A couple of questions from landlords about what are the rules for the owner of the property if they want to move into the property? What are the rules around eviction in that situation?
Right. These rules haven't changed since August, but I'll give you the recap of them. The executive order from the governor says that the landlord has to give a notice to the tenant that they need, it's not defined, but need to move into the rental property, the landlord or their family. And it doesn't define family either. And so it's a little bit speculative what that means, what need means, and what family specifically means. Is a cousin good enough? Is a second cousin good enough? We're not exactly sure. And then once the tenant has left, the landlord has to take possession and move in within 7 days of the tenant vacating as well. There's been one court case, I think, that the Attorney General has filed against a landlord in the last couple months, against a landlord who seemed to not be moving in once the tenant vacated, that they were using it to, it looks like, sell the property. The landlord also has to give a notice tied to this, 7 days under the executive order, or a notice equal to the notice period if there's one described in the lease, which is honestly something that's a little bit tricky to figure out. It might be a month or 2 months, depending on how a lease is written.
Right. Let's see here. Any advice about coming from a Mahmood, a service provider, social service provider, any advice on how to negotiate a lease, what to negotiate the terms of a lease, or the negotiating rent in this situation right now?
Negotiating terms of a lease largely historically has been difficult to impossible for tenants. Honestly, that's why landlord-tenant law exists, is because landlords dictate the terms of most residential leases. And most is very understated. Almost every residential lease in Minnesota, the landlord says, here's my lease, take it or leave it. That's how it's done. The tenant doesn't show up at the door with a lease saying, hey, landlord, I like this lease a lot. It's my favorite. Can we use this one? So it's difficult to negotiate things with a landlord moving into a place. It can be tried, and sometimes it works occasionally, but it's pretty uncommon for any movement at all on the landlord's part. I think that when a tenant has been in a place for a year, negotiating rent, if the landlord says, hey, I'm going to raise your rent, $50 a month this year, tenants have more of an ability to negotiate there on the renewal rates. It still isn't likely or prevalent, but we do see tenants occasionally have some success. The landlord says $50, tenant says, I don't want to do 50, I'll do 20, and they settle on 25 or 30. That can happen. It's very uncommon, but it's more likely than when a tenant is moving in. The market has shifted in the last year. We're actually seeing a little bit more vacancy depending on the area you're in. Some areas there's been no change at all. But if the landlord is a little more desperate, and we're starting to see signs of that, we're seeing more concessions being offered by landlords. They're offering the last month's free, or they waive the application fee, or a very minimal security deposit. Those are the kinds of concessions you'll see. That might be a sign that they're willing to negotiate a little bit more. And it depends on how many empty units they have, right? I mean, it's not any different than a car dealer. If the car dealer has one car left on the lot, they're going to ask whatever price they think they can get for it. If they have 1,000 and they're not moving, they're going to probably lower the price.
We got a question in the Q&A from Peter that's sort of similar to the previous one about the owner moving in, but maybe not actually. Peter says he may need to put his rental unit up for sale. if the tenant's not able to pay rent or get assistance soon. Can a landlord in this situation sell their property?
Yeah, there's no law that stops a landlord from selling their property. None at all. So the landlord can absolutely put their house on the market. They can sell it. They can have a closing, and they can become the the prior owner eventually. And I've certainly talked to dozens, if not hundreds, of tenants in the last year that's what they've done. But that's not different than any other year. Landlords sell their property and move on from the landlord game. So it's not that unusual. But there's no law that stops a landlord from selling a property right now. I think it's harder to do showings currently because of COVID-19. So there's some resistance from tenants that are living in a place saying, hey, I want to limit showings. Can we figure out a way to do that? And most of the time you'll see a landlord try to work with a tenant on that because they figure that it's their best way to have a successful sale. So instead of having a lot of times when somebody puts a house on the market, the realtor will say, hey, look, if somebody wants to see the place, we got to drop everything and let them see it when they want to see it. And that's one way to go about this. The other way, though, is to say, we're going to do an open house on this day and on this day. And I had a tenant that was working with a landlord recently, and the landlord said, we're going to put it on the market and we're going to show it on Saturday and Sunday of this weekend from 2 to 4. And the landlord bought the tenant, lunch, got him a gift card to vacate. That tenant was thrilled to help. They wanted to make the place look like it was in show place condition because they felt like they were being treated respectfully, versus a landlord saying, you know what, we're going to do a showing tomorrow. You need to be gone from 2 to 4 and make sure the place is in show place condition, versus giving the tenant a $10 gift card to Subway saying, I'd really appreciate it if you could be gone then. That tenant was more than happy to help in that situation. But again, no law stops a landlord from being able to sell a property right now. It's just a little bit more complicated with COVID in place.
Yeah, we have maybe 5 or 6 more questions here, and we're after 3 o'clock. So this isn't high school. You don't have to stick around.
Don't chase them away. They want to hear this stuff.
I know. I'm just saying that there's
Right.
not going to be a quiz next month or anything. So,
Mhm.
but we'll stick around until about 3:10 to try to tackle these last few questions. And again, thank you for joining us today. Can a landlord put Teresa, a tenant, is asking, can the landlord put a letter under my door saying your rent is late, saying the lease is going to be non-renewed and there's going to be an eviction when the eviction ban lifts?
Yeah, it can be a fine line, what a landlord is allowed to threaten right now and what they're not allowed to threaten. The governor's executive order says that the landlord can't terminate or non-renew a lease. And so this is one of those situations where I'd want this person to contact us either through our free tenant hotline or our email and attorney service. And we'd like to see the document that the landlord actually gave to see if we think that it's over the line. And if it is, contacting the Attorney General's office is the next step to file a complaint alleging that the landlord is not in compliance with the executive order.
Right. In the Attorney General's office, I'll put the number, their phone number in the chat. They also have a complaint form on their website that's dedicated for the eviction suspension, and it's in multiple languages. I'll put the link there. There's a related question from Julie, a service provider. A notice from the property management that the tenant must vacate the unit for routine, non-emergency maintenance visits. Is that legal?
You'd need some language in the lease that requires it, frankly, I think. And again, we're in the COVID-19 era. And so the privacy statute, which is sort of the most important one here in analyzing this, that predates COVID-19, talks about what the circumstances are of the landlord needing access to the place. And so we actually have and Eric will put this up, we put this together within, I think, the first month of COVID-19 happened, sort of our position paper on what a tenant could do to stop a landlord from coming in or barring entry, or could they? And I don't think that our position has changed much on that. It's a little bit complicated, but the short answer is if a tenant doesn't let a landlord in or doesn't agree to leave while the landlord is coming in, and the landlord and their employees have to be masked while they go into their home, the tenant's home, what can the landlord do? And the normal remedy would be they could file an eviction. However, that's not one of the exceptions for evictions right now. So it's sort of, a tenant has a little more leverage today because of the executive order than they would have in normal times, but eventually the landlord can do things like this. Can they generally make a tenant vacate in order for a non-emergency visit. Again, not unless the lease says something like that. The tenant pays for possession. That's what they get when they pay rent. They buy possession. And so the landlord has given up that right. And again, unless the lease has something in it that says that upon landlord's request, tenant must vacate for a certain amount of time, and that's not a common lease term. It's not usually phrased that way. Forcing the tenant to actually vacate for one of these non-emergency visits, probably not something the landlord can force.
All right. Kara, a landlord, is looking for help and options to eviction when the tenant is not taking care of the property.
So the question we have to ask, again, COVID-19 specific, is the tenant significantly damaging the property, or more accurately, past tense, have they significantly damaged the property? And if the landlord can show that, then yeah, the landlord could file an eviction for that exception to the eviction moratorium.
All right. Another landlord, Karen, is asking that, or saying, we suspect a tenant is in the process of abandonment. Rent has not been paid for 4 months. How do we handle that situation?
So that's always an issue for landlords when a tenant has abandoned and they're just not sure. What I always recommend is that the landlord contact the tenant, or at least try to contact the tenant with every contact point they have, maybe even all the way back at their application, to see if the tenant is vacated, because it's probably in the tenant's best interest that the landlord retake possession and start renting to somebody else, depending on how long the lease was for. Maybe it's really in their best interest to do that. But I mean, the landlord could send a note, again, through all the available channels, text, email, phone call, whatever, all of it, saying, you know what, we think you've abandoned, we aren't sure, but we think you've abandoned your place, and we're going to come in on this day at this time. And then you go in on that day at that time, carefully, with at least 2 people, maybe even videoing it as you go in. Knock on the door, and if you need to use the key because nobody answers, then you take a step in, shout who you are, and you know that you're coming in, and you're just checking to see if anybody's around. And then you do that through each door. You give the knock, you give the warning as many times as you can. You video yourself doing that. But I'm not sure what more you can do to sort of protect yourself as a landlord from any sort of legal liability. Normal times, you might be able to file an eviction, but you can't file the eviction for non-payment of rent. And there's a strategic question of whether that's the right move in that situation, non-pandemic times as well. But what I just described is what most sensible landlords do, is they try to warn the tenant as much as they can, give them advance notice before they try to go in to have a check to see if the place is in fact abandoned.
And question from Dwayne: a tenant moved in a dog without the landlord's permission, and the dog is an aggressive breed and not acceptable to the landlord's insurance carrier. Is that something that could be a evictable offense?
I think the only exception that possibly fits here is that somehow the tenant is seriously endangering others in the property. I'm not sure that the simple ownership of an aggressive breed, whatever that might be, is enough to win one of those evictions using the exceptions to the eviction moratorium, but that would be the only place I think it would fit under the current rules that we have.
And Carmela just has a broad question. Can a landlord ask for 3 times the rent in income? I think during the screening process.
Right, thanks. Yeah, so the 3 times the income requirement is something that some landlords ask for in the application process, that the tenant demonstrates that they have the ability to be able to pay their rent on an ongoing basis. In most of the state, that's perfectly fine. No legal challenge to that. The St. Paul and Minneapolis ordinances that have come online within the last 6 months for both cities do have limits on how much a landlord can ask for as far as a income multiplier is with rent. So you'll want to check on your city to see what that says. But those are the only 2 cities with specific rules on it right now.
All right, so 3 more questions here. Fernanda asks, what is the difference between abandoning and leaving a place early?
That's a fairly subjective question, actually, and it depends a lot on the facts of the case and what the tenant has demonstrated. Again, ideally, when a tenant leaves, if they want to walk out on a lease, that's not necessarily the best thing for the tenant to do, but at least telling the landlord makes sense, because then the landlord can re-rent, mitigate their costs. So an affirmative statement of an abandonment is clear. After that, though, it gets a little bit murky. And again, sometimes landlords just file evictions non-pandemic times because it's the easiest way to be sure that they're not taking advantage of the property, chasing somebody out inappropriately. One thing that I've seen landlords do very rarely is they assume that the place is abandoned after they've done the sort of check that I described earlier. And then the tenant later says, hey, wait a second, I came back and you had changed the locks. What's going on? And then the landlord gives them a lock or a key to the lock right away, realizing, oh, didn't realize you were still active here. But it's a totality of the circumstances, a phrase lawyers love to use, but that's what would be examined by a judge if this were ever brought up in any kind of court.
Does the eviction moratorium apply to individuals living without a lease with a family member who's maybe been generous to this individual, and then that individual overstays their welcome, and maybe their conduct wasn't quite as bad as what would fall under the exceptions to the moratorium, but is nevertheless unacceptable to the family member who's brought them in? And it's also it's unacceptable because the person with the actual written tenancy to the premises, it's unacceptable to them. Is that a situation where the suspension applies?
Okay, so the question that would have to be answered here is the person in question, not the generous one, but the one who's the non-generous one, the non-generous family member, are they a tenant? That's the legal question that would have to be asked first and foremost here. And that's not necessarily an easy question to answer based on what we have here. To be a tenant, there's actually a definition of tenants in the state law, which is not all things are defined in state law. So landlords and tenants are, and that's useful. To get to that status of being a tenant legally, what you really have to demonstrate is that you owe rent, that you have the right to occupy space, and in exchange you owe rent. That's kind of the threshold limit that you have. Now, there are some exceptions to that, because if you think about that definition, why isn't somebody staying in a hotel a tenant? And they actually can be if they stay there long enough, and some other factors. But generally, an innkeeper's license shields that innkeeper, and they say, hey, look, I got the innkeeper status, I'm not a landlord. But in this situation, the question I would be asking, if it was the non-generous family member calling our tenant hotline, because that's the only party that we advise as renters, I would be trying to figure out, are they a tenant? Do they owe anything to stay there? Do they owe any money? Do they have any ongoing debt to stay there? Do they have any ongoing duties? Any chores that they have that are for them only, really, that's their specific job while they're staying there? That's probably enough, because you don't have to pay cash to be a tenant. You can sometimes pay through services, caretaker, leasing agent, superintendent. But it could be, hey, you take care of the dog walking every day. Is that enough? Maybe it is. So that's going to be the key question. Are they a tenant or not?
All right, and our last question from Haimano, service provider. Any idea how many evictions will be filed and how the housing court will handle the cases? I'm assuming after the suspension opens.
Any idea how many are going to be filed? No. Anybody who tells you, hey, we know the number of evictions that are going to be filed at the end of the eviction moratorium is, well, they're more confident than they should be. Everybody's guessing about that. People use numbers that range from, oh, there won't be any. There's not going to be any eviction wave at all. It's just something that tenant advocates are making up, to, oh, it's going to be a third of the renters in the state. I don't know what it's going to be. I can tell you what we know from past years, which maybe doesn't mean much of anything because we're in such an unusual time. Past years, the last 5 years, 13 to 17,000 residential evictions each year. So if you just divide that by 12, take 16,000 evictions, divide it by 12 and multiply it by the 13 months roughly that we're going to be at by the time the state moratorium is over, then you're somewhere between, 13 to 20,000 evictions that might have been bottled up over that time. I think that's probably a sensible conservative estimate. Now, a lot of this money has been paid and there's going to be more money distributed. So the fact that money keeps coming in from the federal government to help with this rental assistance is why we have such a high percentage of the rent that's current, according to the studies that are put out there, where they say, somewhere between 70 and 90% of rent is current in Minnesota. If we didn't have that financial assistance coming from the federal government all this time, it would have been much lower than that, much worse than that. So it's sort of, when you ask the question, what the snapshot looks like, we got this giant stack of money, which, Rachel was talking about for over an hour. And when that gets distributed, is that going to mean that so many more renters are current on their rent? Hard to know. It's really difficult to know. But here's what I am fairly confident in. There's going to be a day at some point in the next year, probably, where landlords are able to file evictions once again in Minnesota for non-payment of rent. And those are the ones that matter, because over 90% of evictions in Minnesota are for non-payment of rent. And on that day, when landlords are allowed to file evictions, they're going to file them. If they want to file them, they're not going to wait until the day after. They're going to go file them that day. They've been waiting a long time to file those evictions. So there is going to be a surge. There's no question. There might be an ongoing series of waves, I'm not sure, as months become due. But there's going to be a lot of cases filed in one day. I have to assume that that's going to be the single biggest one-day filing of evictions in Minnesota's history, and probably projecting out into the future too. And so there's going to be a lot at once. And can the courts handle that? Well, they're trying to figure out how to do that. Lots of ideas have been floated throughout the state. I've heard rumors of weekend and night courts for evictions, just to keep the machine humming, because there's so many cases that they might have to get through. But they don't know either. Nobody's really sure. It's going to be very dependent on how much of this money gets distributed, when the eviction moratorium gets lifted, whether it's the state and or the federal one, to figure out how many evictions are going to be filed. It is the key question. It's something that I'm very concerned about as a tenant lawyer. Honestly, as an officer of the court, all lawyers are officially officers of the court as well, because I want to see an eviction system that treats people fairly, that due process, there's at least the appearance of due process. Anybody that's ever watched housing court in Hennepin or Ramsey County prior to the pandemic, it did feel very machine-like. It just had a factory feel to it. Things got shuffled along kind of in a systematic way. It is a concern of mine that people are going to be wondering, hey, wait, am I getting a real fair chance to say what I need to say in court as a tenant, because they're going to be losing their home? And so that's a concern. Are these cases going to look like due process? Are they going to actually be due process? And the more cases we stack up in one concentrated period, the more of a concern that is. Whether you're in housing court in Hennepin County or district court in St. Cloud or in Crookston or in Bemidji.
And that's a good note to end on, because I think I wanted to again share, it's up on your screen right now, but Mike was talking about the estimates of what might happen when the suspension ends. Well, we have a couple webinars similar to this coming up in the next month. Again, it's going to be, we're taking a 3-week period for the next one. So April 14th will be our next one. That's again the same day that the peacetime emergency in Minnesota is set to expire. So we'll have news about the possible continuation of the Minnesota suspension. The end of this month on the 31st, that's when the CDC suspension is set to end. That might get extended. But then on the 28th, over a month away, but we wanted to give you a heads up because we're excited about this one. The 28th of April, staff from Homeline have been doing a review of the entire past year of eviction filings that happened during the pandemic under the suspensions for the various exceptions. And we're gonna, we did one of these back in October where we did just looking at that period, but this will be a full year. We'll do an overview of the numbers, where the evictions happened, and where and some, sort of what the cases looked like. Last year in October when we did that seminar, it was our #1 most attended seminar. So you can sign up in the chat there, and
yeah, it was well over, I think, 500 to 600 people. I can't remember the exact number. High 500s that actually tuned in to watch that. So there's a lot of interest, and there should be. It's going to be a 1-year analysis, a deep analysis of the eviction, the year that evictions didn't happen, basically, at least for the most part. So should be very interesting.
Yeah, but thank you for joining us today. All of the 101 of you that are still around, you get extra credit for sticking around for 20 minutes past class time. So thank you, and have a good rest of your Wednesday. Bye-bye.